Hi, I'm Jen White. Today on 1A, we meet an award-winning film director driven to tell the story of a man, a march, and a movement. Rustin.
The record should reflect that Justice Margaret Chudich and Justice Carl Procaccini are both recused from this matter and will take no part in the consideration or decision of this case. As a procedural matter this morning, Council, you will each have 3 minutes of uninterrupted time for any opening comments that you would care to make. At the end of the 3 minutes, I will stop you to see if the court has any questions. Just so that we're kind of all on the same page in terms of the order of speakers, we're going to hear first from Mr. Fine, representing the petitioners. Mr. Fine, I understand you've reserved 10 minutes for rebuttal. Thank you. Following Mr. Fine, we'll hear from Mr. Harshorn, representing the Secretary of State, Steve Simon. Thank you for raising your hand. You will be followed by Mr. Nelson for Donald J. Trump and Donald J. Trump for President 2024. And finally, we'll hear from Mr. LeBeau for the Republican Party of Minnesota. Thank you. With that, Mr. Fine, if you're ready to proceed, you may do so.
Good morning. May it please the court and counsel. I'm Ronald Fine for Petitioners, and with me are co-counsel from Free Speech for People and Lockridge Grindle Nowen. Your Honors, this is a case of extraordinary importance. Petitioners ask this court to uphold the U.S. Constitution and defend American democracy. Beginning before the 2020 election and culminating on January 6, 2021, Donald Trump engaged in rebellion and insurrection against the Constitution of the United States in a desperate attempt to remain in office after losing the election. Section 3 of the 14th Amendment protects the Republic from oath-breaking insurrectionists because its framers understood that if they are allowed back into power, they will do the same or worse. Section 3's plain text bars Trump from ever holding office. And this court, as directed by the Minnesota legislature in section 204B.44, must exclude Trump from the ballot. I have 3 main points. First, section 3 is a direct prohibition on office holding. It grants Congress power to remove disqualification, but not the exclusive power to decide disqualification in the first place. And section 3 does not require federal legislation to be enforceable. State courts enforced it without such legislation during Reconstruction, and they do so today. The fact that Section 5 of the 14th Amendment grants Congress power to enact additional legislation does not strip this court of its duty to interpret and enforce the Constitution. Second, Minnesota Statute 204B.44 directs this court to decide petitions involving placement of ineligible candidates. It specifically includes federal candidates, and nothing in 204B.44 or Chapter 207A immunizes presidential candidates from challenge. And nothing in the federal 12th or 20th Amendments or Electoral Count Act gives Congress the exclusive power to resolve questions of presidential qualifications, nor removes Minnesota's authority to protect the integrity of its elections by regulating ballot access. And third, under Section 3, the president is an officer of the United States. No party has disputed that the presidency is an office under the United States, yet Trump claims that he was not an officer, which would make it an officerless office. And he claims that his oath to preserve, protect, and defend the Constitution was not an oath to support the Constitution. These arguments make a mockery of Section 3 and the constitutional democracy that it was enacted to preserve. For these reasons, we respectfully ask the court to schedule a prompt evidentiary hearing. I'll start with Section 3. Section 3...
Counsel, actually, let me stop you there before you go to Section 3. As I understand your principal argument, it's that your clients have a cause of action under Minnesota Statute 204B.44A1 because that's what allows for the correction of an error that has occurred or is about to occur, including the placement of a candidate on a ballot who is not eligible to hold that office. And then it seems to me you kind of dovetail to saying that, well, Mr. Trump is ineligible to hold office because of Section 3 of the 14th Amendment, and therefore this court should order the Secretary of State to keep his name off the ballot. What I'm concerned about, though, let's say you're right. Let's say we agree with you that Section 3 is self-executing and that we do have the authority under the relevant statute to keep Mr. Trump's name off the ballot. Should we, is the question that concerns me the most. And I'm getting at some of the political question, justiciability issues that respondents have raised. Because it does seem to me that you run square into the problem that Chief Justice Chase talked about in Griffin, where you have the potentiality of 50 different states who, depending on the nature of the statutes in those states, deciding this question differently, deciding whether states have the right to determine who's eligible for a national office. And that concerns me, that you have this possibility for, as Justice Chase said, for just chaos. So should we do it, even if we could do it and we can do it?
Thank you for the question, Chief Justice Hudson. The 204B44 provides no discretion for the court to decline, and in particular it says that the court shall decide the facts and order a hearing. And it is not a discretionary form of jurisdiction. The possibility of different states reaching different decisions is actually the way that our constitutional system is set up. For better or worse, we have an electoral college, not a single national election. We have 51 different elections. As a practical matter, Your Honor, if this court were to rule that Trump is disqualified from the primary ballot, I anticipate that he would seek review in the U.S. Supreme Court, which could provide a final answer to the question. And so it would actually be unlikely that there would be 51 different decisions, but that type of argument regarding the patchwork of decisions was addressed by the U.S. Court of Appeals for the Ninth Circuit in Lindsay versus Bowen, which basically said that this is the way our system is set up, for better or worse. And Professor Mueller's amicus brief gives ample examples of courts around the country and different states adjudicating presidential candidates.
But you would agree there's some cases on the other side of that as well. Castro comes to mind and a couple of others. So at best, there's mixed authority out there, and I guess my question then is, doesn't that suggest we use caution and some judicial restraint and maintain the status quo, if you will?
First, if I may address the Castro decisions, those decisions brought by a pro se plaintiff in federal court have uniformly found that he lacked Article 3 standing in federal court, which is not an issue in this court.
So not based on Section 3 that we're dealing with here.
And furthermore, to the extent that they have addressed political question, those issues have not been maximally teed up for the benefit of the court. And if I may give an example, a recent decision where Mr. Castro lost in the District of New Hampshire, the court said that Castro had not cited any authority supporting state adjudication of presidential qualifications, nor could the court find any, and yet we've cited ample authority, as has Professor Mueller's amicus brief. In terms of the court's obligation to say what the law is, I believe that the mandatory language, the only time that the Section 204B44 refers to what the court must do is it says shall, not may, and had the legislature intended to provide a discretionary jurisdiction, the legislature certainly could have.
Professor Mueller suggests, it's interesting that you mentioned his brief, his amicus brief, because he suggests in that brief that he was not aware of any case in which a factual dispute over a presidential candidate eligibility has resulted in a candidate being disqualified. Do you agree with that? I mean, he acknowledges that it's a negative and so maybe hard to prove, but do you agree with that there really isn't any other similar set of facts?
We're certainly not aware of a set of facts under Section 3 of the 14th Amendment with a factual dispute. Of course, this court is fully equipped to decide factual disputes, not necessarily in its appellate form, but through referral to a referee under Section 204B44. That happens often.
I'm struck by I'm struck by the fact that many of the cases that deal with eligibility issues deal with non-factual disputes, age, citizenship, things of that sort. And I'm just wondering if that affects the outcome here at all.
Oh, well, Your Honor, if I may respond briefly to the issue of citizenship, many of the challenges to Barack Obama's candidacy alleged factual questions about where he'd been born, whether he was actually born in the United States. So there have been factual resolutions. They may have been, frivolous factual allegations, but they were in fact factual. And if the state has the authority to exclude a candidate where there isn't a factual dispute, the state's authority is the same regardless of the extent of factual dispute. The state's power flows from Article 2 of the Constitution, which enables it to appoint the electors in the manner that the legislature directs. And in Minnesota, that manner includes the 204B44 process, which often includes resolution of factual disputes, for example, of residency. And so the fact that in some other cases there may not have been a factual dispute has no bearing on that question.
Can I, oh, sorry, go ahead. Okay. Following just kind of up on the discussion of the Electoral College and coming to your third point in your introduction on, I mean, it is kind of weird that the word president is not included in the language when all these other specific offices in a sense are. I mean, I guess maybe members of Congress aren't in office and that's your argument, but does that have to do, it seems like, but electoral college voters are mentioned. And so does the lack of does the fact that we have an electoral college bear on how we should understand, when we vote for president, we're not really voting for president, we're voting for members of the electoral college to go vote in Congress. Does that bear on how we should understand Section 3 and why the president might not be mentioned? Not a very clearly articulate question, but hopefully you get what I'm trying to get at here.
I think I do understand the gravamen of the question, Justice Eason. The President of the United States is not specifically enumerated in the covered officials portion of Section 3. There is no dispute that in the barred offices portion of Section 3, no party has disputed that the presidency is an office under the United States. The only dispute is in the covered officials section. So the Constitution is clear that the presidency is an office. The 1787 Constitution describes the presidency as an office about 24 times. The same is true of federal judges are also described as holding an office. But senators and representatives and electors are not described in the 1787 Constitution as holding an office. So if the Section 3 had only mentioned officer of the United States and had not specifically called out senator and representative and elector, there could have been an ambiguity as to whether senators and representatives were included or not. So they needed to be called out, whereas Article 2 president and Article 3 judge is very clearly an office and therefore its occupant an officer. I also want to point out that there's a very fine-grained textualism inherent in Trump's argument, the idea that officer of the United States is this arcane technical term that doesn't have its sort of natural, ordinary meaning. And of course, that goes against the general principle to construe the Constitution in ordinary terms, as Justice Scalia has highlighted in District of Columbia versus Heller. If it were a technical term of art that lawyers all knew and were expected to learn, especially in the era before law schools, I would have expected Trump to have cited law dictionaries that defined officer of the United States in this precise technical term that doesn't include the president. But they don't cite any law dictionary definitions of officer of the United States, and I think that's because if there was a stream of thought that the president was not an officer of the United States, it was not uniformly agreed on as a technical term of art.
Well, I guess my question about the Electoral College maybe it ties in with the last sentence as well of Section 3, which allows Congress to act, and other provisions of the Constitution that, I mean, basically Congress is the one that's ultimately, in some argument, assessing the qualifications, right? I mean, I think that's partly what the Trump argument is, that there's built into our Constitution is that. And because the president is not, is elected by electors as opposed to directly elected by the people, that really is a decision of Congress to assess those qualifications. Why is that argument not right?
Well, a few points, if I may, on that, Justice Thiessen. So first of all, Section 3 does specifically mention Congress for one purpose only, which is to remove disqualification by a 2/3 vote of both houses. It does not grant Congress any exclusive power to decide disqualification in the first place. Now, of course, Section 5 of the 14th Amendment does authorize Congress to enact additional legislation, but an important point is that Section 5 applies the same way to Section 3 as it does to Section 1. Section 1, of course, the home of the due process and equal protection clauses.
I kind of agree with you on all those points. I guess my question is, though, because we have an electoral college, other parts of the Constitution, like, I mean, the 12th Amendment is weird because it only talks about qualifications related to the vice president, but maybe implicit in that is already for the president, Congress. They understood that Congress had the authority to assess qualifications and exclude people that didn't meet the qualifications. Why? That's kind of more what I guess I'm getting at.
I have a few answers in response to that.
Counsel, before you go there, can I just piggyback on Justice Thiessen's question?
Yes.
In addition to that, it seems to me that you've got the impeachment provisions, for instance, which also obviously are for Congress to decide. And so there's this interplay, it seems to me, with many other constitutional provisions, like the 12th Amendment, and those all seem to suggest that there is a fundamental role for Congress to play and not the states because of that. And the impeachment comes to mind just because of the reasons that, qualify for impeachment. They're very similar to what you're arguing and what Section 3 of the 14th Amendment provides. So it's that interrelation that I think is troubling, that suggests that this is a national matter for Congress to decide.
Thank you, Chief Justice. I'll take those together if I can. So first of all, let's start with Article 2 of the Constitution, which assigns to states the authority to appoint electors. It begins with the states, who then send electors to Congress. Now, the 12th Amendment does not specifically say that Congress can judge the qualifications of presidential candidates, unlike, for example, Article 1, which says that each House of Congress shall be the judge of the qualifications of its members. The 12th Amendment does not say that, nor does the 20th Amendment. If there is some residual power in Congress under the 12th Amendment to consider challenges to qualifications, it certainly is not stated as an exclusive power. And if I can give an example or a set of examples, let's say Barack Obama, who served 2 complete terms. Under the 22nd Amendment, he is barred from seeking, he is barred from a 3rd term of office. To say that a state like Minnesota would be obligated to engage in a charade of listing him on its ballots, many people might like to vote for him, but since he's barred from office, there's nothing that says that Minnesota would be obligated to play along with that and appoint electors for a constitutionally ineligible candidate. In terms of impeachment, the impeachment power refers to a political proceeding governed by political standards. The impeachment process of Trump is not res judicata as to Section 3. And to the extent that there is some overlap between the matters in the petition and the matters in his impeachment, there are many reasons that senators voted to acquit. Many explicitly said a jurisdictional concern, a concern that was also present in the Senator William Blunt and Secretary of Defense William Belknap impeachments, where somebody was out of office. And there's a jurisdictional question as to whether they can be impeached and convicted when they're out of office. That's not present here. That has no bearing on this matter. And finally, Trump's argument that the impeachment proceeding somehow controls this matter would completely turn Section 3's amnesty provision on its head, because Section 3 says that Congress can remove disqualification by a 2/3 vote of both houses. That's a high bar, but Trump is essentially arguing that Congress could exonerate him by a failure of one House to reach a two-thirds vote to convict. And that's why the impeachment power doesn't control. So to loop back to your question, Chief Justice, if Congress has a role to play under the 12th Amendment, which of course is decided on January 6th, 2025, or the 20th Amendment on January 20th, 2025, after the election, that is not an exclusive power. And had our Constitution set up a single national election supervised by Congress directly from the outset, we would be in a different system than we have been for the last 2+ centuries. But under our electoral college system, states appoint electors in the manner directed by the legislature, and that includes the power to not appoint electors for an unqualified presidential candidate. Justice Gorsuch confirmed that when he was on the 10th Circuit in the Hassan case. Lindsay decision in the 9th Circuit recently confirmed that, as well as multiple other decisions that we've cited. And in fact, in a case where Trump himself is party right now in trial in Colorado on similar matters, the Colorado court found that it was not barred by Congress from deciding extremely similar questions.
Counsel, can I ask a question as it relates to sort of timing? Is there a difference between holding office and putting his name on the ballot? And does that impact, or should it impact, our analysis here?
Justice McCaig, the Section 3 prohibits holding office, but Section 204B44 says that you can't run for an office, you can't appear on a ballot for which you are ineligible. And an example coming strictly from state law is that the offices are eligible to be held only by registered or eligible voters under the Minnesota Constitution, Article 6, I believe. And yet, if somebody who was not an eligible voter sought to run for office under Section 204B44, I don't think anyone would say that the fact that that's stated as a prohibition on holding office would mean that they have to appear on the ballot.
Can I follow up on that? Because, I mean, that is a little bit of a different situation, though, because the legislature actually felt the need to pass a specific law to say that the secretary had the power to keep, well, not just had the power, was required to keep the people that have felony convictions, et cetera, deemed incompetent off the ballot, which is a little bit different, it seems to me, because there's actually, I mean, I don't know why the legislature felt the need to actually pass a specific law to give him that power if he already had, or the secretary that power, if the secretary already had that power.
Well, if I may zoom out a little bit, I mean, Section 207A.12a says that except as otherwise provided by law, the presidential nomination primary must be conducted the same as any other state primary. And 204B44A1 talks about any candidate on any official ballot, and it specifically includes.
To come back to the timing question, though, which is troubling me too, is the word eligible in 204B44, is eligibility determined at the time of placing on the ballot, or is it determined at the time of taking office? What is eligibility? What is it referring to?
Well, if I may answer that in two ways. One, with respect to 204B44.
This is a statutory interpretation.
Statutory interpretation question, but I'd also like to briefly touch on the question under Section 3 of the extremely hypothetical possibility that Trump might receive amnesty.
That's what this is going to.
By a supermajority. So starting with that supermajority point, it is extremely speculative that Trump would receive amnesty from 2/3 of both houses of Congress. He hasn't even asked for amnesty to this date. And this court has said that it does not decide questions that are purely hypothetical. He's disqualified unless and until 2/3 of Congress, both houses, grant him amnesty. And then turning back to the state question in terms of the timing, there are other scenarios where a candidate could become eligible later, but is not eligible now. The example, for example, of somebody who has a conviction. The filing officer is directed to remove them from the ballot, notwithstanding the possibility that they could get a pardon by election day or even by the date that they'd have to take office.
Mr. Fine, what do we do about Griffin? Because it seems to me if we follow Griffin, you lose. I recognize that Griffin is not, or maybe you don't, maybe you can tell me why you don't, but I certainly recognize that Griffin is not precedential, it's not binding on us, but by the same token, it is the only case out there that I know of that is squarely on point. And what do we do with that in terms of its value to us? Because, of course, Griffin said that Section 3 is not self-executing.
I'd like to say several points about Griffin. First of all, Griffin arose in a unique context that doesn't apply here, which is an unreconstructed state that did not have a functioning state government. It was not filed in a state court pursuant to a valid state law regarding adjudication of disqualification. It was filed in federal court in an occupied state that was under the supervision of a Union Army general. And so maybe it applies to territories right now, but it does not apply to the state of Minnesota. The second point, which relates to this, is that it said that the procedures for adjudicating Section 3 can only be provided by Congress, but it never explained why states can't do that, and in fact, states were doing that at the time.
Did they need to explain? Did it need to? I mean, I agree, it would have been nice had that explanation been there, but I don't know that that makes it necessarily less persuasive.
Well, Your Honor, the state courts were doing that at the time they were enforcing Section 3. One of them, Worthy versus Barrett, after the gentleman was ruled disqualified, he appealed to the U.S. Supreme Court, which denied the appeal. So the U.S. Supreme Court was certainly aware that this question was being adjudicated in state courts. And in fact, Griffin, the decision itself, mentioned that the full U.S. Supreme Court had unanimously agreed to an alternative basis for the holding, this de facto officer doctrine, which of course has no bearing on the merits of Section 3. I see my time is winding down, so we ask that the court schedule a prompt evidentiary hearing. Thank you.
Thank you, Mr. Fine. We'll now hear from Mr. Harshorn for the Secretary of State. And you have 10 minutes, Mr. Harshorn.
Thank you very much, Your Honor. Good morning, Your Honors. My name is Nathan Hartshorn. I'm an Assistant Attorney General with the Minnesota Attorney General's Office. I'm here representing Minnesota Secretary of State Steve Simon, who's the initial respondent in this matter. As Your Honors are aware, the Secretary's overriding concern in this matter is ensuring that Minnesota's election officials can administer the state's presidential nomination primary in March in the orderly fashion that Minnesotans expect. Minnesota's election system is the envy of the nation. That's in large part because our county and municipal election officials are the envy of the nation. The Secretary's central concern here is that all of these folks are given the time that they need to do their work preparing for the March election. So as we explained in our initial response, Minnesota's election officials need this petition to be determined no later than January 5th so that they can start the election machinery running. Your Honors are aware that the Secretary is not taking a position on any of the merits issues in this case. The one legal issue I did want to speak to this morning, though, is ripeness. As we explained in our brief, we believe this case is ripe for adjudication because the one nominally hypothetical element of the fact pattern here, and that's whether the list of primary candidates that Mr. Hahn from the State Republican Party sends to the Secretary on or before January 2nd will have Mr. Trump's name on it. We would submit that that question is not really hypothetical. And that means there's no actual risk that the court is going to end up issuing an advisory opinion in this matter. Meanwhile, the cost of waiting for that letter from Mr. Hahn and requiring the petitioners to refile the petition after that letter arrives, the cost could be some serious damage to our ability to administer the March election. Then just as my last point, if the court determines that this case just can't be held right because we don't have that letter from Mr. Hahn, we've suggested what we think is a narrow extension of the functional justiciability doctrine that this court has applied to formally moot cases in a small number of situations. What we're suggesting is that the court could determine that it has discretionary authority to hear nominally unripe cases if they've been thoroughly briefed, which is what functionally justiciable means, They're on very important issues of statewide significance, and there's an approaching deadline that's going to cause real problems for Minnesotans or the judiciary if the court isn't able to resolve the legal dispute by that deadline. We believe that if this case is unripe, it would meet those criteria, but there aren't very many other cases that would. And that means that the court wouldn't be opening the floodgates to a whole lot of unripe claims. That's all I have, Your Honors. So I'm very happy to answer any questions the court has about any element of the Secretary's case, but otherwise I'd like to cede the time to the respondents in interest.
No, good.
So, since the Secretary is the expert on our election law, there's some questions about 204B.44, and if you're not, anyway, I mean, one is this question of whether, because the word file is included, in I think it's B, that doesn't apply to presidents because they don't file for office. And if you have any knowledge on why that sentence was, actually two sentences were added, the one down below two in 2015. If you have any insight on that, that would be helpful.
I wouldn't say I have particular insight as to legislative history or any of that legislative intent information. And I have seen that argument about that specific wording in the statute in some of the other respondents' briefs. I do think, my guess is just that the reality that there are some candidates who end up on Minnesota ballots who don't file in that way is just something that did not occur to the legislators who were passing this. What I would say just in general terms, because at least to some extent I think this gets to the merits issues that the Secretary isn't taking a position on. On the other hand, the Secretary in this case I would say is, within this room, the biggest fan of 204B44 as an extraordinarily useful and valuable part of our election system, because it's a focus for election officials and for voters. If you've got a concern about a name that's going on your ballot, don't go harass your local election official. Talk to an attorney about perhaps bringing a petition. So 204B44 is a wonderful element of Minnesota law, and the Secretary believes in it and wants to defend it. To some extent, for that reason, I don't think the level of hyper-literal wordsmithing that the respondents in interest are engaging in there to say, wait a minute, filed isn't exactly the way it works here. That's not how this court has applied 204B44 in, over the last 10, 11 years in these cases. I would point at the 204B44 eligibility cases we cited in our response to the petition, chiefly the Monahan case from 2016, and then a couple cases from 22, which were the Landis case and the Fisher case. And I mean, one interesting point about those cases is there really is very little interest in the court in those cases to decide, hey, who committed an error here? I mean, in Monahan, the word error does not even arise. Error is a big deal in the text of 204B44, and I think a law professor question in a Socratic law class might be, hey, let's look at this Monahan case. Who committed an error here? Petitioners in these cases, including this case, always say, the Secretary committed an error. He put an ineligible person on the ballot. Well, wrong. They always say it, they're always wrong, and yet, in the Monahan case, the Landis case, it doesn't really matter because...
Can I also ask you about the timing issue? And so
Sure.
the language that goes not eligible to hold the office?
Right.
Is it at the time of the placing on the ballot, or is it or do you judge it from the time the person will be taking office?
I think inevitably it has to be the time that the balloting is taking place, because that's what the court has at hand. I thought petitioners' comments on the specific timing issue were correct. I thought the way they put that was right. But specifically with regard to the text of 204B44 question, I think the Monahan case especially, and then to a lesser extent Landis and Fisher, make it clear that this court has understood 204B44 in a sort of holistic big idea sense to mean that this court has jurisdiction, has legal authority under the statute to just deal with the situation when you've got an ineligible person on a ballot. And for that reason, it certainly is the Secretary's emphatic position here that this is the right procedure, this is the right statute. This court does have the authority to rule on the merits here in either direction, in favor of either party.
Counsel, can I ask one question, though? And this may be more appropriate for petitioners, and maybe we'll take it up on rebuttal, but the amici, particularly the Republican National Committee, point out that if the statute works the way petitioners are saying it works and the way it sounds like you're saying it works, it gives the Secretary of State an awful lot of power to determine who is qualified or not qualified to be on the ballot. And with little to no due process, there's no opportunity for a candidate to challenge the determination that the Secretary of State makes. And so, should we be concerned about that?
I think that is a legitimate and a correct criticism of the petitioner's perspective on what the powers of the secretary. But that is the main point of disagreement between the secretary and the petitioners in this case.
Okay, so explain to me that difference then.
Sure. The secretary's position is that he does not have the authority to determine sua sponte, on his own, that a particular candidate for president is ineligible and therefore the name's not going onto the ballot. The allegation from the petitioners is that the secretary has committed or will commit an error by putting Mr. Trump's name on this ballot, even though...
So maybe where I started is the way to go. It's really a question for petitioners.
It is. I mean...
Yeah. And you're saying if you get an order from us one way or the other, you're obviously going to comply with that.
Absolutely, without question.
Okay.
But more than that, the secretary disagrees with petitioners on that point, that the secretary has that kind of discretion. And I mean, this court has brought up the Oinous decision, which there are some things about that, the previous secretary's position in that case that Secretary Simon doesn't agree with. But one clear holding of that case is that the secretary doesn't have exactly that kind of discretion, and Secretary Simon certainly strongly agrees he doesn't have that kind of discretion. Well, if
Section 3 is self-executing, though, doesn't he have a constitutional duty to do that as a...
His position would be no, just that Minnesota statutes don't give him that authority, and generally speaking, administrative officials in Minnesota only have the authority that the statutes give them. So that's all I have, Your Honor, and I'm happy to cede what little is left of my time to the other respondents. Thank you very much.
Thank you, counsel. We will now hear from Mr. Nelson, representing Donald J. Trump and Donald J. Trump for President 2024. And Mr. Nelson, you will have, I understand you're taking 20 minutes and Mr. LeBeau is taking 5, so you have 20 minutes here. But just as a reminder, you will have 3 minutes of uninterrupted time to make whatever statement you'd like to make.
Thank you, Chief Justice Hudson. May it please the Court, Nicholas Nelson of Cross Castle PLLC for President Trump and the campaign. There is no more political question in our constitutional order than who should be president. That's the predominant feature of our national political conversation, and the Constitution itself devotes more words and more provisions to how we decide that question than just about any other. It's for that reason that when parties ask the courts to step into that process and to decide who can or can't be president, the courts overwhelmingly say that's not a decision that should be made in the judiciary. That's a decision that should be made elsewhere. That is what this court held in its Oins decision. It's what most courts throughout the rest of the country have held when they've been presented with similar questions. We've had 2 citations of supplemental authority in this case just in the last week or so. Those courts actually took different approaches to this political question issue, but they used exactly the same phrase to describe the precedential landscape. Both of those courts said that the weight of authority holds that this is a political question, not justiciable. Now, some states have also enacted that consensus into statute and said that this is not something that we want state officials or state courts to be looking at. This gets decided elsewhere. This court in Oins also held that Minnesota statutes do that the legislature has instructed the Secretary of the State and the courts when it wants them to investigate qualifications and when it does not, and that presidential qualifications fall on the do not side of the line. My last remark is simply that all this line of authority reflects an important reality about the purpose of the political question doctrine, which is to ensure that, obviously, political questions and judicial questions remain separate. Political decisions and judicial decisions remain separate. We think that's an important part of a healthy separation of powers. We think Oins reflects that. We think all the other cases reflect that. And we think the outcome should be the same here. I welcome the court's questions.
What about the argument that Owens really only deals with the authority of the Secretary of State and not the authority of the courts?
Well, Owens was a decision of this court where the court was being asked to tell the Secretary of State, you know, what to do in terms of ballot access. I don't understand that to be different from any other Section 204B.44 petition that's been filed. So I think it would apply equally to any similar challenge like this one.
Let me ask you the same question I asked opposing counsel about Professor Mueller's brief, where he asserts that he's not aware of any case in which a factual dispute over a presidential candidate's eligibility has resulted in a candidate being excluded from the ballot. Do you agree that we're in uncharted territory here?
I don't know that the territory is uncharted. I think it has been charted on the other side. I think we have many courts, which we've cited in our briefs, that have said this is a political question. We're not going to get into these sorts of disputes. The petitioners cite a lot of cases where courts held that someone who's known to be disqualified, and I think this is what Professor Mueller was talking about, someone who's known to be disqualified can be excluded from the ballot. And that just doesn't implicate the political question that many other courts have recognized. You know, whether someone who is ineligible can be excluded from the ballot is not a political question. Whether a person is eligible is the political question.
So in your mind, the Hassan case that petitioners cite would fall into that category, someone who's known to be ineligible, or where does Hassan fall?
Correct.
Because Hassan clearly says that it's that states can lawfully exclude an ineligible candidate, and should do so as a matter of protecting the integrity of the ballot and protecting the integrity of a state's election process.
Correct, Your Honor. There were a number of Hassan cases, but I think the one that's gotten the most play is one where the candidate was saying, well, even if I am disqualified to be president, I still have a right to be on the ballot. I still have a right to run. And that was the proposition that was rejected there. Assuming, if it's already established that you're not qualified, then no, you don't have a right to be on the ballot. And that's obviously not the question that's presented in this case.
So you said eligibility is a political question, but if known to be ineligible, it's not a political question. But isn't the whole question of whether you're eligible I don't see that there's really that doesn't seem like a real distinction to me. It seems like kind of a wordsmithing distinction, because how do you know if you're ineligible without determining whether you're eligible? I mean, they seem to go hand in hand.
Well,
it's just kind of what stage in the process you are, and maybe that's your point, but
I think it may be my point, Your Honor. I mean, this is a different case from if we had someone who was 27 years old who wanted to be on the ballot. And
why?
The reason is that there's nothing for the courts to decide about the eligibility question, right? In that, with the 27-year-old, everyone knows that person is ineligible. Everybody agrees that person is ineligible.
So what about a natural-born citizen? I mean, that is a fact question, right? I mean, maybe that would be a political question.
Correct, and that is the great majority of the decisions that held this to be a political question arose in that context.
Yes.
Yeah.
Okay.
Right. The petitioners have cited.
Can you explain the rationale for that? Why that is true? Is it just because it would involve us in fact finding?
Well, I think it's because the Constitution specifies a lot of processes by which we decide who should be president, right? And those are all places where decisions can get made, and this is how we draw inferences about political questions and justiciability. Wow, the Constitution really says a lot about how this should happen, and it doesn't mention the courts, right? Who should be the president? Now, ballot access is very different, right? States have a role to play in saying, you know, do you have enough signatures in your petition to get on the ballot, in creating paperwork requirements. So the cases that say when somebody concedes they're ineligible, when somebody's 27 years old, that falls into that category, right, of just, you know, basic processing requirements. It doesn't fall into the category of deciding major questions about who should be president. And so I think that's where there's this significant divergence in the way the courts see these things.
Counsel, I have a philosophical question to ask you, and that's this. I mean, I think your argument about the political question doctrine is I think that's a very serious problem for the other side on this case. But having said that, the Constitution itself specifically gives to states the authority to deal with elections. And I'm just wondering, what do we do with that constitutional language?
Well, I think it speaks to the same divergence in case law that I was just referring to with Justice Teason, that certainly the states have a lot of role to play in administering elections, but the Constitution does not say that states have a role to play in determining who is eligible to be the president, or making the choice actually of is someone suited to be president. That there's a role for state legislatures to play in assessing, in instructing the electors and that sort of thing, but in making binding legal rulings about who is eligible or not, that's not something that the Constitution says the states should do.
Counsel, let's talk about Griffin a little bit. One of the concerns I have with Griffin, well, let me back up. Would you agree it's not binding on us?
Not as a matter of formal legal precedent. It's a decision of the Chief Justice 10 months after the relevant constitutional provision was enacted, so I think it's extremely informative about the analysis.
And I would agree with you on that. One of the concerns, though, I have with Griffin is I found it interesting that Chief Justice Chase acknowledges early on in the opinion that if you were just to read the language of Section 3 literally, what we would now today call sort of plain meaning, just plain language, common sense reading of it, he reads it exactly as the petitioners read it, that it's self-executing. But then he diverges off of that and says, well, but whoa, if we say it's self-executing, that means, and then he goes into all of the reasons why, the chaos that he talks about. But essentially it was because that would mean that insurrectionists from the Confederate Army would be, who are now serving in various positions, like the judge in this case, would be disqualified. And he says, oh, we can't have that. That's troubling to me when he acknowledges right up front what the plain meaning is. And shouldn't we do that as well? Acknowledge what the plain meaning is.
Yeah, so, there's always a risk in reading 19th century legal opinions and trying to figure out, how it categorizes itself in our modern minds. So there's caution is indicated there. But I think the way to understand what Chief Justice Chase was saying was simply, this constitutional amendment did not come out of nowhere. We are in, at that time, they were in an unprecedented political, historical situation in our country.
They were trying to piece back together a country that had been torn apart.
Correct. And so I think Chief Justice Chase was saying we have to read these provisions in light of the fact that this is where we are, that this is where it came from. And this is the point that we are making. I think you brought this up with Mr. Fine as well, that the idea that the Congress was simply handing this question willy-nilly back to the states that had just been in rebellion is a little bit not something that you would expect at that point in time. And so I think that's what Chief Justice Chase is saying. We can't simply read this with blinkers on and not think about the historical circumstances that we're in.
By the same token, though, in terms of how the country understood it at the time and how Congress likely understood it at the time, petitioners make the very persuasive point that Congress was passing all kinds of amnesty bills to essentially allow, and people were making requests for amnesty who had participated in the insurrection. You wouldn't do that, and Congress wouldn't do what it did if you didn't think Section 3 was already self-executing. They clearly did. They thought it was. That's why they were granting people amnesty.
I really appreciate your raising the point, Madam Chief Justice, because there's something that was not emphasized enough in the briefs that I think is the key to understanding the historical puzzle here. That is the statute by which Congress readmitted 6 southern states to the Union. The citation is 15 U.S. statutes at large, pages 73 to 74. That was passed before most of this was happening, and what Congress said in that statute was that these were states that had put together pro-union constitutions, pro-union governments, about half of the former Confederacy. It was 6 states, and at the end of the statute, Congress said, we are not just going to allow you to enforce Section 3 of the 14th Amendment, we are going to require you to make sure that people who are not eligible under Section 3 cannot hold state office in your states. So when petitioners give examples of states enforcing this, every single one of their examples is from one of those 6 states that Congress had said, you must do this. And then those states had acquiesced in that and had enacted state law provisions that said, basically incorporated the Section 3 quote.
And all the people that applied for applied directly to Congress for the 2/3 waiver? Were they all from those states?
I don't think we've gone into that level of detail in the historical record, but what I would say is whether or not the people were from those specific states, people knew enforcement was there. If it wasn't, if it wasn't on the ground in their state, it obviously was coming, which it was because Congress enacted the Quo Warranto Act, not too long after that. So I think the idea that, Congress had enacted Section 3 and then everybody just assumed nothing's going to happen until there's a statute, so why would anybody seek amnesty? I'm not sure that that's realistic. I think it was being enforced for the reasons that I just explained. In some places, people expected that it was going to be enforced elsewhere. Especially in light of the fact that, at some point, it was radical Republicans who were in control of Congress, and anyone who was reading the political signs would have expected this is coming.
Counsel, if I could jump in here, what does it mean in your estimation to have engaged in insurrection or rebellion against the Constitution? I mean, in other words, what would petitioners have to prove to us to satisfy that standard?
Well, I think we've discussed in our briefing, certainly, the touchstone obviously is the Civil War. It doesn't have to be the Civil War, but that's the paradigm that we're working from. We would say it's some sort of organized form of warfare or violence would be what qualifies as an insurrection that is oriented towards breaking away from or overthrowing the United States government.
So your interpretation is then a historical interpretation based on Section 3 as it was passed in the historical context of the Civil War pretty much exclusively?
I would say that certainly the meaning of the word insurrection in Section 3 has to be interpreted in light of the fact that it was enacted in response to the Civil War.
Well, what do you do with the bipartisan article of impeachment that was passed by Congress that referenced Section 3 and impeached Mr. Trump for incitement of insurrection? Is that a legislative finding that has any bearing on our determination of the issue in this case?
Well, I think if it were, then the Senate's acquittal of President Trump on that charge would also have to inform the analysis. We would say that what happened on January 6th was crimes, some of them serious, was violence, some of it serious, but that it did not reach the scale or scope of what would be regarded as an insurrection.
So what work or what meaning does Section 3 have in 2023, given your interpretation of it? I mean, the briefing suggests that amnesty was passed, that statutes were passed that basically took away the disabilities related to Section 3 issues. I mean, what purpose does that article have in today's context?
I don't know of any current or in the last, say, 50 years set of events that would qualify as an insurrection under Section 3. I'm not definitively saying there was not one, although I don't believe there was one. That doesn't mean, of course, that it's a dead letter. If there were something that happened that qualified as an insurrection, then Section 3 may apply.
Isn't that why we would need an evidentiary hearing? I mean, that seems to go to the petitioner's point.
Well, we've made several threshold legal arguments that do not turn on facts, but I think our position is that you simply read the allegations of the petition, you look at what's in the public record, and it's clear from that that this does not rise to the scope or scale of an insurrection, and in particular that what President Trump did in connection with it does not involve engaging in an insurrection.
So if you conclude that what transpired on January 6th was not an insurrection, then would you also reject what the Republican National Committee says on pages 7 through 9? They give some examples of other things that they think might qualify as insurrection. Would you also agree that those don't rise to the level of insurrection?
I'm not specifically recalling those examples.
Well, they mentioned the riots that occurred in 2020. They mentioned the immigration issues. Those are two that come immediately to mind.
Yeah, right. So now I think that the point that the amicus was making, and it's probably something that we would agree with, is that it's better for our republic if that level of disturbance does not qualify as an insurrection, and we think that the events of January 6th fall in the same category.
Well, I think they were raising it more as a part of the political doctrine issue that, at least that's how I read the examples, Correct. Is that's why you don't want states to get into this.
I agree, Your Honor, and I think the point is well taken that, petitioners would like this to be a one-off case, but, we have a 50-state democracy with a lot of courts and a lot of parties who like to file lawsuits, and so, this may be the first, if this were to be the first decision that someone engaged in insurrection or a president did, it may not be the last, and I think that does inform the political question analysis here.
Counsel, could you address Section 5 of the 14th Amendment? I know you did in your brief, but I'm just not recalling exactly what you said in response to petitioner's argument that is concerning to me, that if Section 5 means that states can't adjudicate questions under Section 3, then they also can't adjudicate equal protection and due process claims under Section 1, but we know that states do that all the time, and rightfully so, and Minnesota does that all the time without, requiring any kind of congressional authority or anything like that. We litigate those claims on a regular basis, and so there seems to be a disconnect.
So, Your Honor, I think, Griffin's case and the precedents that follow that say that Section 3 requires congressional enforcement legislation are unique to Section 3. They're not addressing the 14th Amendment as a whole. They're certainly not addressing the Civil War amendments as a whole. So I don't think this case implicates that broader question. I certainly know there are lots of enforcement mechanisms for the other provisions of the 14th Amendment and things like that. So we certainly would not say that a decision regarding Section 3 would affect the enforcement of other provisions of these.
Even though Section 5 says Congress shall have the power to enforce by appropriate legislation the provisions of this article.
So that, certainly Congress does have that power with respect to every provision. If you draw inferences from the structure, the way Chief Justice Chase did, from the structure of Section 3, from the historical circumstances, from the way our government is structured, that this is just for Congress, Section 5 provides that reassurance. Okay, yes, the framers agreed, Congress can do this. And I would just add to that, that this is the way a lot of provisions of our Constitution work. There are various areas of the Constitution that are reserved specifically to Congress, whether it's admiralty, whether it's bankruptcy, whether it's interstate commerce, and none of them say only Congress can do this, or few of them do. We infer from the structure of our government that that's how it works.
Is the 20th Amendment relevant to our understanding of Section 3 since it was, past several decades after?
Well, certainly the original public meaning of Section 3 is not informed by the 20th Amendment for the reason that you mentioned, Justice Thiessen. But I think that the political question doctrine, is implicated by the 20th Amendment because that speaks to the allocation of decision-making authority, and that can happen anytime, right?
And then just one, are you contesting ripeness, or is that a non-issue for us?
We have not contested ripeness.
Okay.
I see my time is up. We would ask that the court dismiss the petition for lack of jurisdiction or alternatively on the merits.
Thank you, counsel. Mr. LeBeau. And you have 5 minutes, Mr. LeBeau.
Pardon me, I'm not quite that tall.
I have that issue too, I understand.
May it please the court, my name is Reed LeBeau, and I represent the Republican Party of Minnesota. Given my brief time, I would invite the court to ask me questions at any point and waive the uninterrupted 3 minutes. This petition should be dismissed.
Can I just, please. Would your position be that some of the justiciability questions and other questions here are different in a primary than in a general election, like what the power of the secretary would have in terms of ballot placement in a primary?
Yes, Justice. As the courts have stated, and the High Court has stated, I believe on repeated occasions, the states have a much lower interest in presidential elections than they do in any other type of local election. But a function of a primary, and our position has been, the function of a primary is really a purely political mechanism for helping the party determine who its standard bearer is going to be. And that implicates the First Amendment associational privilege, which which the petition is essentially seeking to create a new standard where each party now will have the ability to determine the menu that each other party is going to have for who their standard bearer will be. And we believe that puts far too much of a burden on the First Amendment and the rights that the political parties and their members have.
Well, it would only, well, I shouldn't say it would only be a case, I suppose, where there's facts that would render someone ineligible. Now, I guess, I mean, would the Republican Party take the position that they can't put someone who's 30 on the ballot, or could they?
No, we've not taken that position, and we would not.
And why?
And I would point out, the case law does not suggest, again, petitioners are trying to merge two things together: eligibility versus Section 3 disability. Now, I'd like to get into the statutory dilemma that they've created for themselves in a moment, but every case where there has been a determination that somebody can be taken off the ballot because they are ineligible under Section 2, or Article 2, pardon me, Article 2 of the Constitution, as Justice Anderson has pointed out, the fact that they are 27 years old, the fact that they are not a U.S. natural-born citizen, those aren't in dispute in those cases. Those were never requiring a fact finding to determine that we know that so-and-so is not 35. What we're dealing with here is...
Why does it have to be in dispute, though?
It only up to this point has never been. And those are the cases where the court has said that
so it's more
okay.
descriptive than legal.
I believe so.
And so to Justice Hudson's question, give us a legal reason then.
The legal reason is with Article 2 eligibility, you don't have a large, in-depth fact finding that you have to do to determine whether or not they meet the criteria. Section 3 on disability requires you to actually dig into the facts and determine whether or not a disability occurred. I would point out
Counsel, I would agree with you. It's harder to determine whether someone engaged in insurrection, for instance, than whether someone's 27 or 35. I mean, obviously, you can go look at a birth certificate.
Correct.
So it is harder. But I guess I'm not sure how to weigh that, and maybe that goes towards petitioner's argument, well, that's why we should have an evidentiary hearing to get at the insurrection issue.
The problem, Chief Justice, is that there's no controlling legal authority on what that is. And what petitioners are asking you to do is they're inviting you to create essentially a 50-state standard for who's going to determine what an insurrection or what treason was. Minnesota may have a determination on what that is. South Dakota likely will have a much different determination on what that is. And at the end of the primrose path that they've created, we could potentially have 50 different states with 50 different ballots with none of the same people appearing on the ballot.
Well, although petitioners say if whichever state goes down that, if a state were to go down that road first, that's why we have appellate courts. That's why we have a U.S. Supreme Court, which is where this probably should be decided, and that's how it will get decided.
I would disagree with that conclusion because I think they have a more fundamental problem that the statute simply doesn't allow it. If I may,
can I just ask one more question? You wanted to talk about the statute?
Yes, please.
Could you talk about the statute?
I would love to. As we pointed out in our brief, they have an unreconcilable dilemma. They're asking you to merge Article 2 eligibility and Section 3 disability and say they're the same thing. If that's true, great. You should follow the precedent that you said no.
What's the difference? It just feels like a distinction without a difference.
Well, Section 2 eligibility specifically lists the only qualifications to serve as President of the United States. They cannot be added to or subtracted from by state action. Section 3 disability specifically says something, a broader term with no controlling legal authority for determining whether or not somebody should be rendered or deemed disabled and therefore not able to serve.
So the difference is age, we know what age means, natural-born citizen, we know what that means. There could be a fact dispute about whether someone meets that, but we know what the definition is.
Correct.
But under Section 3, we really don't know what insurrection or rebellion means. Is that kind of the point a little bit?
Correct. There is no controlling legal authority on what those mean, which is exactly why Congress did say that when they created the 14th Amendment, that Congress shall pass legislation to enforce this provision, to create a uniform controlling legal authority for determining whether insurrection had occurred. And they've not done that yet, nor has the state passed any controlling law for determining what that would be.
Counsel, don't go anywhere. I think I might have cut off one of my colleagues. Did one of you have a question?
I would just, no, I guess, no, that's fine. I'm done.
Okay, thank you very much.
Thank you very much for your time.
Mr. Fine, you've got rebuttal now of 10 minutes.
Thank you, Your Honor. First thing I'd like to say is to correct the misquotation of Section 5 that was just made. Section 5 of the 14th Amendment says that Congress shall have power to enforce by appropriate legislation. I'd like to divide my time to talk about Section 3, timing questions, the state law questions, and the political question, doctrine questions. First of all, in terms of Section 3 and this idea that Article 2 of the Constitution provides the only qualifications for the president and Section 3 somehow is a lesser standard, I don't think that the Republican Party of Minnesota would say that about the 22nd Amendment, which would prohibits Barack Obama from running for a third term. It's clear that our Constitution adds amendments as it goes. It doesn't go back and rewrite the original text as some state constitutions do, but that doesn't make the 14th Amendment less a part of the Constitution than Article 2. And the issue of the inconvenience that was raised earlier, courts must follow the law even if it is inconvenient. Now, Chief Justice Chase publicly opposed Section 3 before it was ratified on the basis that it would cause inconvenience, but it was in fact ratified as part of the Constitution, and then he used that inconvenience argument in the Griffin decision, but this court follows the plain text of legislation.
It seems like in Griffin, the biggest concern that he had was that it was going to void hundreds of judicial and legislative decisions. Is that implicated now in this particular, at this point? That seems like what his real concern about inconvenience was.
Absolutely, Your Honor, and that distinguishes this in several ways. So first of all, the de facto officer doctrine that the full unanimous Supreme Court adopted resolved that issue, saying that if somebody was de facto in a position, that their past decisions of criminal sentencing and so forth would not be voided, even if they were later found to be disqualified.
And he didn't want to do that so he could make this other decision?
And
it kind of got rid of his inconvenience explanation.
Correct, and perhaps he couldn't persuade the full court to adopt his self-executing position. We don't know exactly, but to the extent that the public remarked upon the decision and to the extent that they favored it, as we cited in our reply brief, it was because of that aspect, which is not at issue here.
So does that go to that there wouldn't be an issue with the decisions made by then President Trump from the 6th through the 20th of January post the events?
We're not seeking to invalidate any actions that by then President Trump during that remaining
You
period.
might not be, but others might be. So the question is, what's your interpretation of, does that de facto officer doctrine answer this question or not?
I think the de facto officer doctrine would address that question in full, and that apparently the unanimous full Supreme Court agreed to it. Secondly, I want to move on to the issue of readmitted states, this newly raised argument. A few things. First of all, the Constitution applies in all of the states of the United States, and there's no area where we say that a constitutional provision only applies in certain states. Furthermore, that the court is not bound by that particular history, but rather the text of what was enacted.
And can I just, 2 quick questions on that? Was North Carolina one of those 6 states?
North Carolina was one of those.
And were all the people that applied for amnesty or whatever under the 2/3 provision, were they all from those states?
No, and in fact, in our brief, I believe in the opening brief, We cited amnesties, including from states that were not included in there. I believe Tennessee is an example of one. So people were applying from all over the South for amnesty. I want to now talk about the timing question.
Counsel, if I may, before you get to the timing, the question that I wanted to come back to is the discussion I had with Mr. Harshorn. And I said is an argument probably better for you, a question better for you. As I understand your petition, your position all along has been, yeah, the Secretary of State does have the authority to declare someone ineligible under 204B.44. And if that's true, it does seem like that's an awful lot of power in one person, in one individual, particularly when that disqualification can be made, it appears, without any type of due process for the candidate being disqualified. I mean, they don't have any, there's no mechanism that I can see in the statute for them to challenge that in any way or to put in any evidence about, showing any kind of disagreement. Am I reading your position correctly? And if I am, should we be concerned about that? And I guess the reason I am concerned about it is you could hear just from today, and certainly you see it in the briefs, that insurrection kind of might be in the eye of the beholder, and so it depends on who's doing the beholden.
Thank you, Chief Justice. I'd like to answer that in three ways. First of all, if the Secretary of State were to remove a candidate on that basis unilaterally, they would be able to file a 204B44 petition to challenge that before this court. So it would not deprive them of due process. It would be essentially a preliminary decision subject to judicial review. Secondly, we're willing to bracket out the question for this purpose of whether the Secretary would have had unilateral authority to do that, because the Secretary didn't. What's clear is that this court has the authority to correct it, and importantly, this court has.
So are you backing off of your position that? Because the very initial pleadings we got from you were saying, no, the Secretary has the authority to do this. Am I wrong about that?
Your Honor, for this purpose, we're willing to set that aside and focus on this court's authority. And notably, this court has authority to correct errors under 204B44, as I believe the Secretary's Counsel mentioned, even if the filing officer didn't have authority unilaterally to exclude someone in the first place. And the classic example of this, in Monahan is a great example, is where someone submits an affidavit of candidacy. The filing officer is specifically directed upon somebody questioning it to look at the address in the affidavit of candidacy to determine if it's within the district. And if the address listed in the affidavit is not within the district, to remove them. But nothing authorizes the filing officer to investigate whether the person really lives there or has really lived there as long as they say they have. And so but this court in Monahan versus Simon, in Studer versus Kiffmeyer from 2006, has engaged in fact-finding to remove a candidate who didn't really live where they were said to in the affidavit of candidacy. So this court corrects errors under 204B44 even if the filing officer didn't themselves have a unilateral command or even authority to make that determination.
Counsel, if I could jump in here. I asked your opponent the fundamental question of what it means under Section 3 to have engaged in insurrection or rebellion, and the answer seemed to be really historically tied to the historical context of the time. I think in the briefing, the suggestion is that Section 3 was an unusual remedy and was put to rest by passage of other amnesty provisions and after Reconstruction. And I guess I'm wondering what your view is of how operative that language is in the context of today. I mean, what is the meaning of that language? What do you have to show to establish that to a court?
Well, first of all, Professor Magliocca's brief includes extensive citations of members of Congress saying specifically this is intended to last for the future. This is intended to apply to future insurrections and rebellions. The definition of insurrection or rebellion against the Constitution is historically informed, of course, by what had come before. Rebellion, as an example, actually occurred before the insurrection in the Civil War, when the southern states seceded before the shots were fired at Fort Sumter, that was a rebellion. And in fact, John Bingham, the framer of the 14th Amendment, or the principal framer, described it as a rebellion before any shots were fired at Fort Sumter. An insurrection has always been defined as a concerted, forcible resistance to government authority to execute the laws. An insurrection against the Constitution, in particular, would be a concerted, forcible effort to prevent or obstruct execution of a central constitutional function. And that distinguishes it from an insurrection against any federal laws like tax laws, and it certainly distinguishes it from riots or insurrections against state governments. And that's the core meaning of Section 3, is an insurrection or rebellion against the Constitution, and in particular, the rebellion against the Constitution, just like in the Civil War, actually began before it culminated in an insurrection, with a series of steps that we outlined in the petition that occurred in late 2020, culminating in the January 6th insurrection.
Counsel, is that your answer, or at least in part, to your opponent's statement? I think it was to Justice Thiessen, that, well, we can determine age very easily, we can determine, other eligibility criteria, but we don't have a legal definition, or we don't have a way of defining insurrection.
Your Honor, the terms insurrection and rebellion are as open to judicial enforcement as any other terms in the Constitution. I want to furthermore address the point that they made along with that about a lack of disputed facts in certain past cases. There's no case anywhere saying that this court's jurisdiction is limited to cases of undisputed facts. The existence of disputed facts is not a material distinction. In every eligibility challenge, the court must make factual findings. In some cases, they're undisputed. In some cases, there's not much dispute. Legislative residency challenges often involve extensive fact-finding, but in all cases, it must make factual findings. And as applied to the political question doctrine, they've stated that exactly the opposite way. The definition of a political question under Baker versus Carr is something that is not susceptible to judicial resolution, but rather requires application of political discretionary judgments. But this court, like other courts, is very skilled at interpreting legal terms in the Constitution and applying them and fact-finding. That's not something outside of judicial competence, and that's why it's not committed to a political branch to decide.
Counsel, your time has expired, but I know Justice Thiessen has an additional question.
Yeah, I just wanted you to give you a chance, and maybe you did this early on, but to talk about OINS and whether that's binding on us, and if it is, how it's binding on us.
Thank you, Justice Thiessen. OINS was, of course, dictum building on dictum that has then been superseded. The briefing by the pro se petitioner, of course, addressed the latches question, which is what the central briefing was, and the decision of for all these reasons, the decision focused on latches, and the further statements made in dictum, again relying on superseded dictum, are not binding on this court.
Superseded. Sorry.
There's a sort of a cascade of dicta in which OINS cites a California case, Keyes v. Bowen, which cites a federal case, Robinson v. Bowen, which has since been a dictum in each step, which has then been overruled by the Ninth Circuit in Lindsay versus Bowen. OINS is not binding on this court.
Thank you very much to all of the attorneys here today. This matter was well argued. The court appreciates the help that you've provided to it in deciding this issue. The case is deemed submitted, and we will make our decision in due course, and we are adjourned. Thank you.